you very much, Mr. Chair. My name is Kathleen Hagenian. I represent the Michigan Coalition Against Domestic and Sexual Violence, and we are the network of the Rape Crisis Centers, domestic violence advocacy organizations across the state of Michigan. We have provided written comments to the committee, I believe. I can give you another copy of that in case anybody doesn't have it. I also brought with me today an article by Dr. Daniel Saunders. He is a professor at the School of Social Work at the University of Michigan. He has testified on this issue to the legislature, though not this committee or this legislature in the past, but when this issue has come up previously. And he did very much want to be here today, was unable to because of the commitment of the university, but he did provide me several copies of a very recent, revised in 2007, article on the issues of child custody, visitations, and decisions in domestic violence cases. And so I would like to make sure that he gets this, and if you do have a future hearing, I know that Dr. Saunders would be available, and I also know he'd be willing to be with any of your committee members individually.
Absolutely. Just let me interrupt for 1 second. We're losing some members. We have some are chairs and have other committees. We're supposed to look at 10:30. We're going to go to 11 o'clock. I lose this room. My best, but I didn't want you to think, or anyone else testifying, that we're losing members because they don't care about this issue. Some are being called to vote, and we're doing the best we can today. Kathy, I didn't mean to interrupt, but continue. I didn't want you to think that people were leaving, or anyone else, because they didn't want to hear what you had to say.
Appreciate that very much, Mr. Chair. Because our comments are in writing, I will only hit a couple of points that I think are especially relevant and maybe have not been mentioned. People have mentioned current Michigan law, so I don't need to belabor that, but we certainly do recognize that. The one thing we do think is important under current law, and while we certainly can agree that the implementation of the current law may leave something to be desired, especially from the perspective of victims of domestic violence, what is written, what is the underlying principle is sound, that when the parents cannot come to an agreement, because when they do come to an agreement, the court by and large does order that agreement and is required under law to have clear and convincing evidence not to enter that agreement. But under current law, when there is a dispute as to custody, the judge is to make an individual determination regarding the best interest without a presumption before a hearing. So the slate in essence is clean. Is it what one party asks for, the other party asks for, or something in between? And there will be a best interest hearing. That is really important, especially in cases where there is domestic violence, where there is substance abuse or untreated mental health issues, or a variety of other issues. I believe as one witness already testified, there are reasons why people leave relationships and have to have the court decide the custody of their children. And those reasons need to be heard, and the parent asking for the court's intervention or assistance should not be penalized or viewed as less. We are not opposed to joint custody. The coalition's position does not oppose joint custody at all. As a matter of fact, we recognize that joint custody can certainly be successful, but the research and experience indicates that for joint custody to be successful, for children, parents must be highly motivated, committed to co-parenting in different households. They have to be willing to compromise, communicate, and safety is a necessity. These components are not always present in cases that do not involve domestic violence, but they certainly are not present when domestic violence is part of the equation. So regardless of the laudable intent of presuming that children of divorced parents should be raised equally by both parents, it must not supersede the child's need for safety and stability. Ms. Shimke, I believe, alluded to in 1979, California pioneered similar legislation and repealed it in 1994. Okay? They did have a study of over 1,000 families in which it was found that within 1 year of the order, most children were actually living with one parent. But more importantly, parents did not become more cooperative over time. In another study in which parents voluntarily agreed to joint custody, 1/3 had changed their arrangements to sole custody, citing problems such as children feeling conflicted loyalties between parents and logistical difficulties. Okay, those are in cases that didn't necessarily involve domestic violence. Imagine the complexity and the layers that would be entered if there was violence in the equation. Both of these studies actually did look at parents who voluntarily sought joint custody, so it was not court-appointed custody. So again, that underlies our concern that in cases where it was actually ordered by the court rather than the parents agreeing to it, that the difficulties will just be exacerbated. I will skip part of this again because you have it in writing, but I do want to underline that batterers often use children to manipulate their partners. A threat of, if you leave, I will get the children, as unthinkable as it may be to many people here who would never imagine, if you were sitting on the bench, that you would let that happen. Dr. Saunders' research bears that out very clearly. As a matter of fact, it's right up front in the first paragraph of his paper, which I will not read to you. I'm sure you will have a chance to read with everything else you will leave this hearing with to read. But after a victim does leave a relationship, batterers often use children in custody disputes, visitation, and joint custody arrangements as an opportunity to threaten, intimidate, coerce, and harm. And quite frankly, this presumption would be a legal tool on a silver platter handed to abusers to continue their power and control tactics without having to risk any type of criminal penalty. It's not illegal to manipulate through the child custody system. And the sanctions don't come into play until much further down the road. So I think those are the basic points we would like to raise. If you do have time and you get to another card that was submitted, we do have, and it is very difficult, as Ms. Shimke alluded to, for somebody who has lived with domestic violence, who has survived that experience, to be able to come forward in a public forum like this. It's hard enough to come forward in the courthouse and be able to state what has happened. But to have to do that and overcome a presumption besides would be completely daunting. That being said, it's even probably, in that situation, you'd be doing it in the best interest of your children, and most victims rise to that occasion because that is what they know they must do. To come here before the legislature is a whole other situation, but we do have an individual who is willing to do that, and who is in the audience today if we're able to get to her testimony.
Thank you, Kathy. Are there other questions? Thank you very much.
Is this the clerk?
Absolutely.
Thank you.